Hello everyone, I'm Dr. James Devaney and I'm a Senior Lecturer in International Law here at the University of Glasgow. Today I'm going to give you a short mini lecture about one of the most vibrant and important areas of international law, international investment law. Now, you might never have even heard of international investment law, but no matter where you are from, it's very likely that your country is bound by this type of international law. And this type of law actually may influence the decisions that your government takes in the best interests of its citizens or not. And this type of international law may even allow private companies to sue your country and take them to secretive international tribunals where a small handful of international arbitrators can decide on whether decisions taken by your government actually make your country liable for up to billions of dollars of compensation. At this point, you might be asking yourself a few questions like, how do more people not know about international investment law? Or why was this system created in the first place? Or maybe even, how can we get rid of this system or how can we reform it? And it's these types of questions that I want to very briefly touch on in this mini lecture today. So, first of all, what is international investment law? And I think in order to answer this first question, we need to take a step back and we need to make sure that we understand what this thing called foreign direct investment is, or FDI for short. Foreign direct investment, in very simple terms, is when a company from one country, an investor, makes an investment in a different country. An example of that might be, imagine tomorrow in Angola, a new oil and gas field is discovered. And then maybe a Dutch oil and gas company is interested in extracting that oil and gas. If the Angolan government, who would get some of the share of the profits that the Dutch company would make for extracting and selling that oil and gas, if they make an agreement, then this would be a type of foreign direct investment that is central to this body of law. Why do states and investors engage in foreign direct investment? And the answer that the textbooks tell us is that it's a mutually beneficial activity. So what's in it for the investor? Going back to our example, well, maybe the investor, the Dutch oil and gas company, maybe it gets access to some natural resources which are not present or are scarce in its own country. And there are a number of other reasons why investors might want to do business in a country other than the one in which they are incorporated in. Maybe they get access to a new market. Maybe their costs are lower there, their labor costs, their production costs. Maybe regulation is more lax, which makes the cost of doing business cheaper. And what's in it for countries? Well, they, at least theoretically, they also benefit because maybe jobs are created. Maybe they get to share in tax the profits that are generated from this investment. And maybe the foreign investor brings with them skills or technology that are not present at that moment in the country where the investment is made. So if it is a mutually beneficial endeavor to both the investor and to the state, then great, right? So then the question is, why do we need to get law involved here? Why do we need to regulate foreign direct investment? And the answer to this question lies in the nature of foreign direct investment itself. FDI is a type of long-term investment, which requires quite a substantial, in most cases, upfront outlay on the part of the investor, and very often the passage of a long period of time before the investor sees any return on that investment. And in the meantime, the investor incurs risk. Why? Because the place where the investor has made that investment, well, that is regulated by the foreign country. The foreign country has, like all other sovereign states, the ability to raise taxes, to introduce new laws which might impact the investment, like new health and safety legislation or environmental legislation, which might make it less profitable for the investor to enjoy their investment. So, international investment law was developed essentially to try and mitigate this risk that the foreign investor incurs. And by mitigating this risk, the idea is that the law also makes that foreign country a more attractive place for investors to go and do business. And so again, this is a type of mutually beneficial system. And in support of creating this system, almost all countries all around the world have signed literally thousands of binding international agreements to create, set up, and regulate this system. They've also created a kind of system of courts as well, which allow foreign investors to actually bypass the national courts of foreign countries and actually go straight to international arbitration to have their cases dealt with not by judges of the foreign country, but in fact just by a handful of investors who are typically not from the country where the investment is made. So again, the question arises of, well, if this is mutually beneficial for everyone, then it should be that all's well that ends well, right? Well, no, not really, in fact. In reality, since this system has been created, it's been the subject of a number of really significant criticisms, culminating most recently in what has come to be known as the legitimacy crisis of international investment law. And that's the second thing that I want to talk to you about today. So, is this label of the legitimacy crisis of international law merited? EU Trade Commissioner Cecilia Malmström, for example, said that the system created these courts, Investor State Dispute Settlement, or ISDS for short, said that this is the most toxic acronym in Europe. Or another legal commentator said that ISDS is an evil which needs to be abolished. So in class, we dig into these types of criticisms and we see, okay, what is the root of them? And we examine a number of them. So for example, people say that international investment law in general and ISDS is a system which is biased in favor of investors who at least traditionally were from rich states in the global north. And, well, for example, because international investment law only gives investors rights and doesn't impose obligations on them. People also say that international investment law is secretive or somehow operates in the shadows, and to a certain extent that is of course true. But is it true to such an extent as to be completely illegitimate and require reform? Or what about the identity of these international investment arbitrators? Does it matter that these are mainly men, educated again in the global north, deciding on policies of states who are elected to act in the best interests of their citizens? Again, these are questions that we dig into in class, and we really make up our own mind as to whether the legitimacy crisis label is one which is warranted or not. It's an exciting time to study international investment law, actually, because today states are getting together very regularly through the United Nations, the Commission on International Trade Law, to consider to what extent they believe international investment law has to be reformed. And the European Union, for example, has even gone so far as to propose the creation of an international court for investment, a multilateral investment court, in an attempt to make it more transparent and to make it less secretive. And we'll also in class look at these types of proposals for reform, and ultimately it will be up for us all to decide whether we believe that international investment law is a system that can be reformed, or whether, like some states believe, such as Brazil, it's a system which is beyond saving and needs to be abolished. So hopefully this has given you an idea of what international investment law is, some of the criticisms of the system as it is at the moment, and perhaps some indication of where the debate in the future might go. And hope that one day we might see you here at the University of Glasgow to engage in these discussions together.